Today we're going to talk about the Public Law Outline 2014. On the 22nd of April 2014, the Public Law Outline 2004 for Care, Supervision and Other Part 4 Children Act 1989 Proceedings was introduced, and it came with a number of amendments to the previous Public Law Outline. In this video, I'm going to take you through the various amendments or the new things which have been introduced, and quickly take you through the whole process, and of course bearing in mind that the focus is avoiding delay and keeping the welfare of the child as paramount. The PLO to the Public Law Outline, that is 2014, has been amended so that there is now a window for the case management hearing of not before day 12 and not later than day 18 instead of the fixed by day 12. A number of other amendments have also been introduced, including the amendment highlighting any international element. The application form C110A has been further revised to include applications for emergency protection orders. This will be required for any new application issued from the 22nd of April 2014. It will now be possible to apply for a Part 4 and emergency protection order proceedings at the same time and on the same form. In addition, the threshold statement and allocation proposal form, which were previously annex documents, have been incorporated into the form. The first stage of the Public Law Outline is the pre-proceeding stage. It is an essential ingredient in the PLO, the Public Law Outline procedure. It is essential at this stage because the local authority would have been working closely with families to ensure, where possible, that key steps are taken to help parents address problems in a timely manner. When a child cannot remain living with his or her parents, the local authority should identify and prioritize suitable family and friends placement if appropriate, otherwise known as connected persons assessment. Where possible, identification should take place before care proceedings are issued, as it may avoid the need for proceedings. However, when parenting is not improving enough to protect the child from significant harm, the local authority should hold an early legal planning meeting to obtain legal advice about a particular case. At this meeting, the local authority should then decide whether it is the best interest of the child to provide a further period of support for the family with the aim of avoiding proceedings, or whether proceedings should indeed be initiated immediately. If the decision is taken to undertake a formal pre-proceedings process, the local authority usually will send the parent or anyone else with parental responsibility one of two letters before proceedings. The letter will either be a pre-proceedings letter which states that proceedings are being contemplated, or a letter of issue which states that proceedings are being initiated. Briefly, a pre-proceedings letter should culminate in a meeting setting out clear expectations and timescales for improvement to reduce potential for delay, while also providing an opportunity to avoid proceedings. Where this is deemed appropriate by the local authority, informed by the views of other professionals involved in the case, then this is the appropriate course of action. A letter of issue, on the other hand, is a letter sent to parents or other persons with parental responsibility when the local authority considers that proceedings are necessary to safeguard the welfare of a child. At this stage, and if the intention is to issue proceedings, the local authority will collate the necessary documentation for the proceedings. However, it should be emphasized that a lack of proper documentation should never prevent the local authority from bringing the case to court quickly, where it believes this is essential to protect the child's welfare. These type of cases should not be the norm, and documents should be prepared in line with the Public Law Outline of 2014. The new Public Law Outline introduced the pre-proceedings set of documents. The first set is known as the Annex Documents, that's ANNEX documents, and the second set of documents are known as Pre-Proceedings Checklist documents. Annex documents are the documents specified in the annex to the application form, which are to be attached to that form and filed with the court. And those documents include the following: a social work chronology, a social work statement and genogram, the current assessments relating to the child and or the family and friends of the child to which the social work statement refers and on which the local authority relies. Another document is called Care Plan, and yet another document is what it's termed Index of Checklist Document. We're now going to consider what is included in an index of checklist documents. The checklist documents are documents which are already in existence in the local authority's files, and they are generally divided into two. The first set is called evidential documents, and the second set is known as decision-making documents. We're now going to look at the evidential documents. This includes previous court orders, including foreign orders and judgments, and reasons. Evidential documents includes also any assessment material relevant to the key issues, including capacity to litigate, Section 7, and Section 7 is a separate document, and Section 37 reports. Evidential documents include single, joint, or interagency materials such as health report, education report, home office report, immigration and tribunal documents. The second set of documents relates to decision-making records, and these include the following: record of key discussion with the family. Another one include key local authority minutes and records for the child. Another set of documents under the heading of decision-making record include pre-existing care plans, for example, child in need plans, looked after child plan, and child protection plan, which are already in existence. Under this heading, decision-making records, we also have the letter before proceedings. It must be borne in mind that under this new PLO public law outline procedure, that only checklist documents in the evidential documents, in other words, the evidential documents, are to be served I repeat, only checklist documents in the evidential document are to be served with the application form. Checklist documents relating to the decision-making record are to be disclosed on request by any party. I'll just repeat that for clarification. The documents relating to decision-making records, which you can always look back on when you rewind this video, these documents do not need to be served with the application form, but they are to be disclosed on request by any party. It's worth bearing in mind that checklist documents are not to be filed with the court unless the court directs otherwise. Checklist documents, including the evidential documents and the case record, these documents are not to be filed with the court unless the court directs otherwise. And older than 2 years, documents which are older than 2 years before the date of issue are not needed to be filed unless reliance is placed on the same by the local authority. In other words, documents which are older than 2 years really should not be added to the bundles, unless of course the local authority is seeking to rely on those documents specifically. They go to the issue. Now we've looked at briefly the pre-proceedings stage of the PLO, the public law outline.